Hello, this is Matt on the Moon Lambo channel. I have two topics to discuss with you in this latest Moon Lambo Hot Jam. Attorney Jeremy Hogan has stated emphatically that the SEC cannot win summary judgment. And so you'll recall that both the SEC and Ripple have filed their motions for summary judgment. It's now up to the judge to determine which side wins, or, as an alternative, decide if there should be a jury trial. So there's a few ways this could go, but one way it won't go, according to Attorney Jeremy Hogan, is the SEC will not win. And don't mind hearing that one bit, so I'm going to share with you his analysis, and also something truly strange and bizarre happened. The developers of a large cap cryptocurrency, out of nowhere, just admitted that their cryptocurrency was a security when it was launched, but today it's morphed and it no longer is. Weirdest damn thing I've seen in a long time. So we'll be talking about that as well. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here is Attorney Hogan's analysis on why the SEC can't win at summary judgment. Why the SEC cannot meet its burden on at least one element of the Howey test. In order to win at summary judgment, the SEC has to do two things. Number one, prove every element by the greater weight of the evidence, and number two, prove that there is no genuine dispute of a material fact. And so pause note, when it comes to summary judgment, this is the SEC arguing that just as a matter of law, there's no reason to have a jury trial. You should enter right here, the SEC's correct. But if there are disputes of facts, then, well, their motion for summary judgment should fail. And so this is more so the SEC and Ripple putting forth their motions for summary judgment and saying that, okay, they're both arguing that the facts are clear. Now, the SEC's wrong about that, but they're both arguing that the facts are clear, and it's more so, how do we apply the law? That's more so what's being discussed here. Attorney Hogan continues and says, looking at the expectation of profits based on efforts of others prong, what do we see? First, the SEC's sole evidence is statements from Ripple and a handful of purchasers about Ripple's involvement in the price of XRP. It abandoned its expert witness on this issue. Yeah, so I'll pause to note, and Attorney John Deaton wrote about this in his amicus brief, but the SEC had an expert witness who had claimed to understand why holders of XRP purchased XRP, and his assertion was that it was all done for, investment purposes, speculative purposes. And when pushed on that, it turns out that he ended up admitting, okay, well, based on this new information that's been presented, because obviously there are thousands of XRP holders who have signed sworn affidavits as to why they purchased XRP and for non-investment purposes. And then he said, okay, well, I'm going to need to do more research. And so that just killed that expert witness's opportunity to help the SEC there. And then Attorney Hogan continues and says, Ripple counters the SEC with its own expert witness who correlates XRP price action with market forces, especially since 2018. And Ripple apparently also files 3,000 affidavits from Deaton and XRP holders that they were not looking to increase XRP price. Burden met? ? Seems to me, tell me if you disagree, the SEC has absolutely failed to meet its greater weight of the evidence burden. A handful of statements over 8 years versus expert opinions and 3,000 affidavits. But even putting that aside, is there a genuine issue of material fact here? Well, Ripple has submitted direct, hard evidence that a reasonable XRP purchaser was not relying on Ripple to increase price. I don't see how the judge ignores that evidence and grants summary judgment on this prong of the test. Not saying the SEC can't win, but it can't win here. Exactly. So if the SEC is going to win, they're going to have, there would have to be a jury trial. If there's a jury trial, there's an opportunity. Otherwise, SEC loses here. And by the way, I'll note that Attorney John Deaton, after reading the SEC's motion for summary judgment, came to the same conclusion. And he kept thinking, because look, we didn't have all the evidence. I'm not that we still do literally now, but we didn't have all of the major arguments that the SEC was going to make at, for most of the last 2 years. And so Attorney Deaton has said publicly, he's like, well, look, going into this thing, and I started reading the a motion for summary judgment from the SEC, I thought that there's probably going to be something really powerful, maybe even some sort of smoking gun that favors the SEC, but it just wasn't in there. So not looking so hot for them, and that's good stuff. Now on to the next topic, which is just weird. You guys familiar with Polkadot? Polkadot is a large cap cryptocurrency. It's currently number 13 in terms of market cap, with a market cap of $7.9 billion. Well, look at this tweet from Web3. I'm not going to read the whole thread, but read just the top here. Look, Web3 Foundation states, Web3 Foundation announces Polkadot's native token DOT, D-O-T, has morphed and is software, not a security. And Polkadot, this is the official Polkadot account with 1.3 million followers, they retweeted that and they agree. They wrote, Polkadot's native token, DOT, initially offered, sold, and delivered to purchasers as a security, has morphed and no longer is a security. It is software. So I read that and I was like, this is the weirdest damn thing I've ever read. Like, why would you put that out there? It's not going to help you. And so, look, somebody asked, why would you publicly declare that it was sold as a security and tagged Attorney Hogan and Attorney Deaton and Attorney Filan? Well, Attorney Hogan responded and wrote, the Polkadot ICO excluded U.S. citizens, so it might be confident admitting it to the SEC. That said, the thread is strange and awkwardly worded, very weird. Yeah, okay, so the SEC makes all the time all sorts of bogus assertions that it should not be making. So that's why if I'm Polkadot, even if I launch the ICO out of the United States, if I want to have the United States participate in any capacity, I'm keeping my damn mouth shut, because I'm just saying, like, they will sue anyone for any damn reason, no matter how illogical. So it's just strange that this was offered. And I'm not saying that Polkadot, by the nature of it existing, ever was a security. So I'd actually disagree with Polkadot there. I don't think by the nature of a cryptocurrency existing that it just is. And so Attorney Bill of the XRP community retweeted that from Polkadot and said, why admit that when you don't need to? At least you are apparently limiting the comment to initial sales and offers and not all secondary market transactions, or stating the token itself is a security. All right. And again, so I should clarify, though, fair enough, they didn't actually say that the token itself was, but still it was sold and delivered and purchased as a security. So that's like pretty close, pretty close. Now, somebody responded to Bill named Bootknocker and said, I don't believe they are limiting anything. There's no legal authority that allows a token to morph from a security to a non-security. If it was sold originally as a security, that's what it remains today. Yeah, and I'll say in a general sense, I tend to agree with that. My arguments that I've made in the past go to the point that even though that's true, and that's not some sort of policy of the SEC, that's not law, I've noted that if a cryptocurrency is sufficiently decentralized, then there cannot be a common enterprise. And so that takes out the prong right there. So I still think, the decentralization thing does matter. So in that sense, it can quote unquote change, but not in the way that's written here. So I actually still agree with what was stated there. Now, Attorney Bill retweeted that and said, yes, I am not a fan of the proposition that a token which is a security per se, could change into not being a security. It comes down to specific sales or offers. Now note, Attorney Bill did not state that he believes that a cryptocurrency per se is a security. He's saying that he's not a fan of the idea of a cryptocurrency being a security per se and then being able to change into a non-security. That's what he's saying, just to be clear. And somebody responded to him and seemed to have missed that important nuance and wrote, using the Clayton-Hinman-Gensler process, not actual law, which it appears you are subscribing to, would mean that either ETH and XRP are securities or both are not securities, because they virtually started the same way, yet only ETH was granted not being a security, ? And then Attorney Bill responded to that and wrote, that is not my position. Exactly. So the individual did miss that important nuance I just cited there, but Bill says, that is not my position. Firstly, I generally accept the position in the UK and Australia that tokens are a new form of property. A token will only be a security in the sense used by the UK law commissioners when they refer to a security token, e.g., is a tokenized equivalent of a security, e.g., stock with the same rights as a stock. Yeah, exactly. So if you have a tokenized version of a stock, okay, that is functionally different than what we're talking about, so sure. And then Bill says, secondly, I do not think that cryptos like Bitcoin, Ethereum, or XRP are, were, or ever could be securities per se. And again, so I'll pause note, another way that it can be characterized, this is how I characterize it anyway, is that by the nature of it existing, not securities. So when he says per se, that's what I'm always thinking anyway. And then he says, sales of offers of them could be under the Howey test depending on how that sale or offer is packaged. Thirdly, outside an ICO or initial sales and offers, the Howey test is highly unlikely to apply generally to secondary market sales. No contract privity, no common enterprise, and so on. Fourthly, even if theoretically Howey could be stretched to cover secondary market sales, it is just an American test in respect of globally traded assets. Why on earth would any American regulator acting in good faith even seek to stretch it this far and make American exchanges trade at a competitive disadvantage to foreign exchanges? There has been too much focus on whether Howey applies to cryptos and not enough focus on why the SEC is trying to stretch it to apply. And finally, I don't think cryptos are commodities. Bitcoin maxis might consider Bitcoin fell intact from the sky or under the ground, but calling them commodities is just a desperate U.S.-centered attempt to get the U.S. market regulated by any regulator at all other than the SEC. Pause. Fair enough point. And I have stated myself, even like, look, anything to get the SEC's grubby mitts off this. I was like, if Congress, whoever's in charge, whoever has power, decides that cryptocurrencies, including XRP, are commodities, okay, fine, whatever. I'm not saying that I think that necessarily is the most reasonable designation, but I'm saying, fine, I don't care. Just as long as the SEC, as long as there's a path forward, I will just make peace with it, even if I don't think it's logical. So, anyway, Attorney Bill continues. Who is calling them commodities outside the U.S.? This is just a commodity free pass grander in scale than the Ethereum free pass, which is supported, it seems, by politicians in Congress with certain interests. People need to know how unfortunate it is for crypto to be regulated as either a security or commodity if that regulation is stifling. It needs regulation light, or its fascinating quality of being an immediately liquid asset that can instantly transfer value will be compromised. Great thread, Attorney Bill. I find that to be fascinating, and I think that all makes sense, frankly. So how about that? You guys tell me how you feel about all of this. The SEC looks like there's about 0% chance they're going to win motion for summary judgment. And Polkadot just admitting that they sold through ICO a security. Okay. It's weird to even say that if it's outside the United States anyway, because securities laws outside the United States are not even close to the same as they are in the United States. There's only like one or two other countries that have something even similar to what we have here in the United States. So it's just kind of weird, but I'll wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.